Very good afternoon to all of you. I welcome you to the 94th webinar of corporate professionals on the topic of succession planning through trust. In absence of Mr. Pavan Vijay, I will be your host today. First of all, I would like to thank you for joining in such good numbers as always. Your continued support and patronage is what keeps us motivated to continue journey of sharing knowledge. Today's topic, succession planning through trust, is very relevant in the context of our country, where 80% of the businesses, as per various studies, are being run by family houses, and is also relevant considering the uncertainties that COVID has brought in both the businesses and our personal life. Succession planning is both very imperative to any organization. Internally, in terms of management hierarchy, we plan how to manage resources internally as a part of the organization. And then on the external, succession planning plays an important role in the ownership hierarchy of the organization. And in our today's webinar, the discussion is on the external element, that's the ownership hierarchy, where we'll discuss the issue related to succession planning. Why succession planning? The first and foremost question. I think with businesses being growing leaps and bounces, and families being big families running such businesses, there are various possibilities of frictions being developed between the various family members. And at times there is also various differences between the new generation in terms of the manner in which businesses will be carried, or they might not have same interest or value addition to the business being run. So therefore, there is an imminent need of succession planning to avoid a situation where there is no one left to carry on the particular business, and which may harm the interest of all the stakeholders. So therefore, succession planning is very important. And what benefits it basically brings? It helps in creating a transition of wealth from generation to generation, avoiding conflicts between family members, creates tax efficiencies, and there are a lot of other inherent advantages. And it is important to note that in listed companies, there is a growing trend of individual promoters being replaced through trust by way of where the aim is to achieve tax efficiency and the other objectives of succession planning. Even SEBI, considering the said requirement, has liberalized the procedure of interstate transfer between promoters to trust, since there is a growing number of such cases or such transactions happening. In today's webinar, our key topic areas to discuss will be to discuss on the importance of or need of succession planning, issues arising out of tax-related issues with respect to succession planning, transfer of shares from listed entities to trust, both in listed entities and unlisted entities, and other related important things with respect to creation of trust deed, impact of takeover regulations on transfer of shares in case of listed entities. And we have a galaxy of speakers with us to discuss on all these topics. To start with, we have Dr. R.K. Agarwal, who is the senior partner at Rakesh Shah's and Associates and is a seasoned professional. We have Mr. Rakesh Arora, the senior general manager at Subros Limited, and Mr. Sanjay Mal, chief financial officer at NIT Limited, and they both will be joining soon. Then from corporate professionals, we have Mr. Manoj Kumar, who heads the M&A and transaction advisory team here. And we have Mr. Ravi Prakash and Ruchika Sharma, who are the associate partners at corporate professionals. They will be sharing their relevant experiences on various topics we will be discussing today. So to begin with, I'll request Manoj to take this forward by sharing his presentation on the overview of forming the trust and the requirement related to succession planning. Over to you, Manoj.
Thank you, Ankit. As Ankit has already told that succession planning is very, very critical for all business houses across the world. and India is not an exception. In India, many of the companies, in most of the companies, are run through by a family-owned structure, where promoters are very important. And for proper continuation of business or non-disruption of businesses, it is very critical that there is a proper succession planning. And hence, and one of the very important tool for succession planning is private trust, which is the topic of today, and it is very important. We have seen many of the cases where, due to proper planning, the family businesses got disrupted due to insolvency, bankruptcy of one of the entity, or any. There are many other circumstances also, and hence we have advised on many of the occasions the two promoters to form family trust and transfer their shareholding into that, or other properties also. It is also very important and helpful in transferring the legacy of the property and assets of the family to next generations. So let me start my presentation by sharing my presentation here. So as we have discussed, worldwide 70% businesses are run through family businesses, and India is not an exception. The family face unique management challenges because of the different aspects, different generations. As Ankit has already told, that different generations or family members may not have the same view with respect to the management, and hence the entrepreneurs who form the business always want certainty or continuity of the business, and hence they try to found various means and modes to create a proper succession planning so that the business is not disrupted. So one of the very important aspect, as I told you, is the formation of private trust and transfer the assets on business of the company into that, so that there is no disruption to the business. What is a trust? A trust is, if in simple term, it is a relationship. It is a relationship, or it is an obligation which is given to someone to manage the assets for the benefit of someone. So this is a very simple thing. And in India, it is governed primarily by the Indian Trust Act 1882, which is continuing. Here it is clearly saying that this is the obligation attached to ownership of the property, which is vested on someone, which is called the trustee, for the benefit of someone else, which is called the beneficiaries. So what are the major parties to a trust? The first person is the person who is transferring the assets for the benefit of someone. So that is called the author or settler of the trust. The second one is the trustee, who is vested with the right and duty obligation to manage the trust. So that is the second and very important party, which is the trustee. And then third one is the beneficiaries. So beneficiaries are the person or persons for the benefit of whom the assets are being transferred into the trust. So there may be more than one settler, there may be more than one trustees, and there may be more than one beneficiaries. The trustee becomes the legal owner, whereas the beneficiary become the beneficial owner. The same person, in many of the cases, the same person may be settler as well as trustee. There may be a same person who is the settler as well as the beneficiary of the company. So generally, 2:3 ratio formula is established principle in case of any trust. A person cannot hold all the three positions, otherwise there is no purpose of the trust. So a simple structure of a trust is that a settler is transferring some assets to a trustee, making that trustee the legal owner of the asset, legal owner of the trust, who is holding and who will be managing the assets of the trust for the benefit of the beneficiary. So this is a very simple structure of a trust. Why it is why a trust is created? There are many factors. Some we have already discussed. One of the most important factor is to protect the assets of the family or a business. It protects the assets from the bankruptcies. In case there is a bankruptcy suit against the person, it cannot go to a property which is already transferred irrevocably in a trust. So that is one of the very important protection. Then if there is a family disputes, the assets remain outside the dispute, and that is one of the very important aspects. Similarly, sometimes the trust is created as part of the will to avoid the long drawn process of probation of the will and then transfer of the property. So these are one of the some of the important objective behind formation of a trust. Then there may be autonomous and accurate control over the trust. So for the purpose of if the settler and the trustee both have a specific functions to perform in a trust structure, the settler cannot control the day-to-day affairs or ownership of the trust property after the trust asset is transferred into a trust through a trust deed. So trust deed is the governing charter through which management of the assets under the trust happens. Then the trust creation helps in preservation of the family wealth. It makes very important. It is very important, as we have discussed. There can be split in the family there after the succession of the next generation. But if the property is transferred to a trust and the beneficial interest is determined, nobody can challenge those after the transfer of the creation of the trust. So the asset remain preserved for the future generations without disruptions. Then one of the, as I have discussed, in case of a will, there is a possibility to revise the will multiple times. Then there is also, whenever there is a death of the person who has created the will, there is a requirement of probation of the will, which may be a long drawn process. And sometimes if the property is outside the country, or the will is created outside the country and it need to be enforced in another jurisdiction, it becomes very time consuming and cumbersome process. Whereas if it is the asset is transferred to a trust, it becomes very simple. Trustee will enforce it as per the will. So that is one of the way to avoid the probate and hassles of the same. Then there is a lot of flexibility and confidentiality in the trust structure. Trust deed content need not be disclosed to the public at large, like in case of company, where the memorandum article is public document, or in case of LLP, the deed is public document. The trust deed is not a public document. It remains in the four walls of the persons who is creating the same. Similarly, there is a lot of flexibility. There can be various kinds of trust. It can be revocable, irrevocable, discretionary, non-discretionary, and a combination of the same. So it makes a lot of flexibility. Then it can also be used as a tax planning tool, because trust is generally a separate legal entity, and hence for the purpose, if there are certain benefits which can be availed through tax planning purposes when we are transferring assets to a trust. So in case of formation of private trust, what are the major benefits? So one of the very important benefits is it is a simple and very effective way to manage the family assets and to pass it to generations. Then it safeguards the interest of the family members when the author or settler is not there. So if the trust deed is clearly saying what to do, where, how it will be distributed, how the assets will be distributed, how the proceeds of the assets will be distributed, it will be very beneficial for those members who are not very much capable, maybe having certain special needs. So for that, it is very, very good mode of creation of safeguard. Then there can be, it minimizes the disputes among the family members, because everybody knows what is the share, how they will get the benefits. It also protects the properties for the benefit of the beneficiaries, like in case there is a insolvency proceedings, and the property is already transferred by the person long back in a trust, family trust. Then the banks or financial institutions or creditors cannot go to the trust and ask for the property, even if the settler had given personal guarantee or corporate guarantee for the benefit of the creditors. Then it is a very flexible structure, and it helps to prevent and restrict the disintegration of the shareholding of a family businesses. So family shareholding is transferred to a trust, and it remains there for the benefit of the family members, but it cannot be sold or transferred or distributed or by the members of the family. So it creates the continuity of the business. It can be a precautionary exercise to avoid attachment of assets, as I have already told you, in case of liquidation or insolvency event. Then settler may mention such terms as he wants at the time of formation of the trust deed. and there can be it can ensure that the ultimate benefit of the beneficiaries as well as of the settler can be secured. So formation of trust, how it can be formed. So trust formation is very, very simple. There is, under the law, unless there is a transfer of immovable property, there is no requirement of registration of a trust. It can be unregistered trust, it can be without any deed. However, it is always advisable to form a trust with proper trust deed, having all the contents relating to rights and obligation of the trustee, and the way or mode of distribution of assets or proceeds of the trust to the members. Any trust, a trust can be, private trust can be created for any lawful purpose. So there is no requirement that how, what is the purpose, whether it is for immovable property holding or for transfer of share, or maybe for family office maintenance. So it can be for all the purposes. Then trust can also be created or declared under the will. So in such case, as soon as the person, the author or settler goes, the trust is automatically created and the property goes into the trust. So these are the basic premise with respect to formation of a trust. There are many kind of trust. One is the specific trust. A specific trust means where the assets, the beneficiaries are known and determined in the trust deed. That is called the specific trust. Then there can be a discretionary trust where the beneficiaries are determined but their share in the benefits of the trust deed or trust property is not determined. It remains in the hands of the trustee to distribute or not to distribute, or to distribute in what ratio he wants. So such kind of trust is called discretionary trust. Then there is the irrevocable trust and revocable trust. Those trusts where the assets which are transferred into the trust cannot be taken back by the settler is called irrevocable trust. Whereas when there is an option for the settler to take the assets back to him, it is called revocable trust. Then if trustee, if any of the beneficiary transfer its own assets into a trust, it will be deemed to be a revocable trust, because that beneficiary is the ultimate person who will gain the benefit of the assets at a later date. So in such case, it will be deemed to be a revocable trust. Then testamentary trust means any trust which is created through will or after the demise of the persons. There may be some other form of trust also. I think broadly I have already discussed that the discretionary trust is the trust where discretion lies with the trustee would have the discretion to decide what to distribute and when to distribute any of the assets or corpus of the income of the trust property. Then non-discretionary or determinant trust is where the beneficiaries are determined and their share in the benefits are also determined. So in case of non-discretionary trust, the beneficiaries are just the beneficial owner, but they have no right to ask for the distribution from the trustee. They have to wait for and hope whether and when the trustee would decide to distribute, they will get the benefit from the trust property. Then revocable trust is such trust where the author or settler can revoke the trust anytime and take the asset back or any part of the asset back. So this type of trust is basically created where the purpose is to manage the assets of the company, like in case of family office. The benefit that the person who is creating the trust is generally transferring the assets for the management by a professional trustee, and the benefits or the corpus can anytime be taken back. In such cases, it is called the revocable trust. Then irrevocable trust is such where assets once goes to the trust can never come back to the trustee. The author or the settler. Testamentary trust is the private trust which is created under the will of the person who is settling it. So trust will get created or arise as soon as the settler dies. So what will be the steps to form a private trust? So private trust can be formed through an agreement or a deed which is called the trustee, where a person who is the settler would create a trust deed and transfer some assets which may be movable or immovable or maybe cash to some person and give him right and obligation to manage that asset for the benefit of the beneficiaries. So it is created through an agreement. It generally it is registered, and it is registered with the Registrar of Society Trust and Trust Society and Trust. And in case transfer is for immovable property, if the transfer is being done immovable property, it becomes mandatory to get the trust registered. So as I have already discussed, the simple structure of the trust is one trust, one asset or one or more asset which is transferred into that trust. There is a trustee, one trustee who is managing those assets and for the benefit of the beneficiary. However, there can be many complicated structure of the trust, considering the complication of the family assets or the settler's asset business. Like there may be more than one son of a person, and he wants different ratio of distribution for each of the son or son's family, and there may be different class of businesses or assets for the purpose of the person who is settling the trust. So he may create a master trust under which there may be separate assets. Some operating companies are held under one trust, then investment companies may be held in another trust, then properties and assets, land and building may be kept in a separate trust, and master trust would govern the interplay among the various assets. And then there may be another trust which are held for the meant for specific benefit of one of the son, let's say. So there may be two sons, so there may be two separate trusts which are getting benefits arising out of the master trust, and then it is distributed for the benefit of the family members. So this kind of complex structure, there can be multiple layers of trusts which is allowed, even for multi-jurisdiction trusts are there, and which helps in the planning, tax planning, as well as succession planning of the business families. So generally in India, the trusts are taxable. Stamp duty, trust registration requires stamp duties. So, and that is on the basis of the value of the assets being transferred into the trust. In case the asset being transferred is an immovable property, then it is mandatory to get the deed registered. Otherwise, also it is advisable to deed registered. Generally, it is planned that a small asset is first transferred. A small movable property, maybe 10,000 rupees, is transferred in a trust deed, and it is registered. Later on, further assets may be added as part of the governing deed for provisions, and for that no further stamp duty is required. So first a small trust is created, and then additional assets are added, so that there is minimum stamp duty obligation in case of formation of trust. One of the most important aspect is the taxation. So now I would briefly deal with some of the basic taxation aspects. There, under the tax, there are only two major class of trust. One is revocable trust and another is irrevocable trust. In case the trust is revocable trust, that means the asset can come back to the settler. Then the trust is not considered to be a separate entity, and the taxability will be in the hands of the settler itself in the same rate as the settler would otherwise be taxable. So whatever the class of asset it may be, the same way it will be taxed as the settler would have already got the tax liability. In case of irrevocable trust, there can be two scenarios. One, if there is a business income in the trust, then the taxability will be at the maximum marginal rate, which is in case of who are the beneficiaries. If the beneficiaries are individuals, then what will be the maximum marginal rate, which is at present maybe 42.7% up to 42.7%, starting from nil. So considering who are the beneficiaries, and based on the beneficiaries rate of taxability, the tax will be imposed or in the hands of the trustee, who will act as the representative assessor of the beneficiaries. So in case of non-business income or other income, the trust is determined, share of beneficiaries is known, then the income tax would be in the hand of the trustee in the same manner as the beneficiaries are there. In case it is not, the beneficiaries are not determined, then it will be taxed in the hands of the trustee at the maximum marginal rate. So that is the present scenario. So as I have already told, in case of under section 61 of the income tax, in case it is a revocable trust, the taxability will be in the hands of the settler or the transferor. And the income taxable in the special rate, let's say long-term capital gain, it will be taxed at that rate. And in the normal circumstance, it will be taxed at the individual's tax rate. In case of irrevocable trust, trustee will act as the representative assessee, and representative assessee would pay the tax on behalf of all the beneficiaries. There may be situations where beneficiary may directly pay the tax, and then that may be taking an adjustment for the trustee, and trustee may not pay separately the tax. So private revocable trust, where there are certain circumstances where the tax rate will be in the hands of the trustee at the maximum marginal rate. That is the maximum rate which may be applicable to the individual beneficiaries, which is right now including cess and education cess and surcharge becomes 42.7% around. So where the income represented by the trustee consists of income other than income from the business and profession, that is a business income, where the income is not specifically receivable on behalf of the benefit of one person, or where the individual share of the persons who are the beneficiaries are not known. In all such circumstances, the taxability will be at the maximum marginal rate. Then residential status, where again for the purpose of income tax, the residential status of the trustee would be the same as of the beneficiary. So if the beneficiaries are individual Indian resident, then the taxability will be the trustee will be considered as resident. In case it is not, then or in case there is a combination, then there will be separate determination of tax in the hands of each of the persons. At the time of transfer of asset from the settler to the trust, it is clearly exempt under section 47(3) of the Income Tax Act. So there will be no capital gain when the settler transfer the asset in the hands of the trustee. Then there is a special provision under section 56(2)(10), where there is a provision of deemed income. So as we have already discussed that the trustee is just a pass-through. He is holding the assets for and on behalf of the beneficiaries. So at the time of transfer of assets to the trustee, it is not a taxable event. It is well-settled position. There will be no tax because the beneficial owner, he is taking the obligation to manage and distribute the assets to the beneficiary. So this obligation would be sufficient consideration, deemed to be sufficient consideration, and no tax need to be paid. There are some very important judicial pronouncements with respect to the trust of under Supreme Court. So one is the trust is regarded as discretionary trust. It is beneficiaries in whose hand the income to be assessed. So all taxation calculation and everything has to be based on the status of the beneficiaries. Then in case of CR Nagappa, which is where the beneficiary of the trust were a minor child, the matter went up to Supreme Court, and Supreme Court held that though the minor cannot be taxed separately, but the the assessment in the hands of the trustee is correctly done, and the trustee need to be taxed in case the income is more than the threshold where there is an exemption. So these are some of the very important judgments. Based on that, trust taxation is determined. There are other laws which also deals with and which have implications of the trust, creation of trust, like in the Companies Act. In case the trust is a significant beneficial owner, then the trustee need to disclose their status, and that as per the new Companies Act. However, in general circumstances, for any trust, the company is not supposed to take notice of the trust unless it is specifically intimated. Under SEBI law, in case the shares of a listed company is involved in the directly or indirectly transferred to a trust, then there is a requirement, there may be implication, there can be a requirement of takeover open offer obligation, unless a specific exemption is taken. I think Ruchika will discuss this part in detail. Then there can be residential issues, non-resident to resident transfer, investment outside India. So there can be FEMA implications. and the beneficiaries' residential status will determine what kind of tax applicability, FEMA applicability would be there. So I think those things after this, I would stop here and we will discuss, we will listen to Dr. Rajkumar Agarwal sir. He will give his views on this. Thank you very much.
Thank you, Manoj, for such a detailed presentation covering various aspects of types of trust and manner in which can be registered and some tax implications. Now I'll invite Dr. R.K. Agarwal to share his views on succession planning and most importantly on key tax related issues that one should keep in mind while undertaking such kind of planning. Sir, please.
Thank you, Ankit. And Manoj has made a very comprehensive presentation covering all the aspects regarding the formation, why a trust is formed, what are the benefits, what are the tax implications. Very lucidly and very comprehensively, he has covered everything. Generally, what we have seen, that why there is a need and why the instrument of trust formation is popular. Generally, what we have seen, when a business is created, first generation does a lot of efforts, labor, they अपना खून पसीना बहा के वो एक venture create करते हैं. And we have witnessed that second generation may not be interested in carrying on that business due to the hardship and the efforts which are continuously required to run that kind of a venture, which is in billions or of high stake. And second generation maybe 20-25% interested नहीं हो सकते, 70-75% फिर भी interested होते हैं, लेकिन third generation में तो आप ये मानिए कि 75%, more than 50% third generation entrepreneurs are not interested in running that business. They may be interested in some art, some music, some hobby, in some other thing. Generally, and this is the cycle of Lakshmi. कहते हैं लक्ष्मी 3 जनरेशन के बाद रुकती नहीं है, कि ये साइकिल रहती है कि जहाँ फर्स्ट जनरेशन खड़ा करती है, दूसरी जनरेशन उसको एंजॉय करती है और तीसरी जनरेशन उसको मतलब साइड लाइन हो जाती है, डिस्ट्रॉय कर देती है या उसको कैरी नहीं कर पाती. तो ये जो एक स्टडी है या एक साइकोलॉजी है, इसको कैसे एड्रेस किया जाए. जनरली सेकेंड और थर्ड जनरेशन either may not be interested in running the venture, because running a venture is a high risk job. Lot of continuous efforts are required. You cannot take relaxation at all. If you want to create a business entity of billions of worth and having the thousands of employees employed in that, high risk is there. Always you have to remain at your toes. But they may not be interested, second or third generation, जो कि सिल्वर स्पून के साथ होते हैं, उनको लाइफ के कंफर्ट्स और एंजॉयमेंट चाहिए, बिजनेस के लिए एफर्ट्स करने पड़ते हैं, और दे मे नॉट बी कॉम्पिटेंट ऑल्सो. जो कॉम्पिटेंस फर्स्ट जनरेशन या जिसने प्रमोटर्स ने उन्होंने वेंचर खड़ा किया, नॉट नेसेसरली कि सेकंड जनरेशन, थर्ड जनरेशन एंड ऑल मेंबर्स ऑफ दैट सेकंड और थर्ड जनरेशन मे बी कॉम्पिटेंट एनफ टू रन दैट काइंड ऑफ शो. तो इन दोनों प्रॉब्लम्स को एड्रेस करने के लिए ट्रस्ट फॉर्मेट है. अब ट्रस्ट फॉर्मेट की ब्यूटी क्या है कि जो भी प्रमोटर्स होते हैं, फर्स्ट जनरेशन होती है, वो ये चाहते हैं कि भाई जो भी हमने वेंचर क्रिएट किया, ये वेंचर चलता रहे, इररेस्पेक्टिव ऑफ द सेकंड जनरेशन और थर्ड जनरेशन इज इक्वली कॉम्पिटेंट और नॉट. तो उनको उसके बेनिफिट्स तो मिलते रहें, लेकिन जो उसको रन करने की लाइबिलिटी है, उसको कंट्रोल करने की रिस्पॉन्सिबिलिटी है, वो उसे डीलिंग कर दें इफ दे आर नॉट दैट कॉम्पिटेंट. कई बार फैमिली में कोई हैंडीकैप्ड बच्चा भी हो सकता है, कोई लेस कॉम्पिटेंट भी हो सकता है, कोई हो सकता है कि बाहर चले गए हों. सेकंड जनरेशन, थर्ड जनरेशन में काफी लोग बाहर चले जाते हैं. अब उनको यूएस पसंद आ गया तो वो कहते हैं ठीक है, हम तो यहीं पे सेटल हो जाएंगे. कईयों को लगता है कि अब तो हम क्रिकेट ही खेलेंगे, आजकल वैसे भी जरूरत है, इतनी आईपीएल चल रहा है, इतना वो गेम चल रहा है, तो हमारा शौक डेवलप हो गया, तो स्पोर्ट्स भी चले जाएंगे या कोई आर्ट और म्यूजिक कर लेंगे, लाइफ जिएंगे. ये हर समय पैसा कमाने में लगे रहें, उसकी वजह हम जिंदगी जीते हैं. तो ये जो एक विचारधारा में बदलाव आता है, एंड दिस इज ए कंटिन्यूइंग प्रोसेस। लेकिन जो फर्स्ट जनरेशन है वो चाहती है कि इतना बड़ा वेंचर खड़ा किया है, उसमें थाउजेंड्स ऑफ एम्प्लॉइज काम कर रहे हैं, इतने स्टेक होल्डर्स हैं, क्योंकि उसमें शेयर होल्डर्स भी कई सारे स्टेक होल्डर्स बन जाते हैं, शेयर होल्डर्स भी हैं, आपके कस्टमर्स भी हैं, आपके एम्प्लॉइज भी हैं, सीनियर एम्प्लॉइज भी हैं, एंड वेंडर्स भी हैं, आई मीन उन सबका स्टेक इन्वॉल्व होता है। तो दे वांट कि सबके स्टेक्स का टेक केयर हो। अब वो कैसे पॉसिबल है? उसके लिए ट्रस्ट फॉर्मेट है कि बेनिफिट्स तो लीगल हेयर्स को मिल जाएंगे, लेकिन उसका कंट्रोल, रेस्पॉन्सिबिलिटी उनको ना जाए, और कंट्रोल एक बोर्ड ऑफ ट्रस्टीज बना दिया जाए। और बोर्ड ऑफ ट्रस्टीज जो भी डायरेक्शन सेटलर देना चाहेंगे उसके हिसाब से विद इन देयर लाइफ टाइम और आफ्टर देयर लाइफ टाइम टिल दे वांट मे बी 100 years ahead, द बोर्ड ऑफ ट्रस्टीज उसको कंट्रोल करते रहेंगे। इट डिपेंड्स कि हाउ डू यू प्रोवाइड इन द ट्रस्ट डीड, कि कंट्रोल किसके हाथ में रहेगा। बेनिफिशियरीज मे नॉट गेट द फुल कंट्रोल ऑफ रनिंग द बिजनेस ऑफ, और आई विल से कि फुल कंट्रोल ऑफ ओनरशिप नहीं मिलता उनको। दे आर ओनर ऑफ द इनहेरिटेंस, जो उनको असेट्स मिली, बिजनेस में जो इंटरेस्ट मिला, एट द सेम टाइम वो उनको बेनिफिट तो मिलेगा। बेनिफिट क्या होगा? भी उनको डिविडेंड मिल जाएगा। अगर वो वर्किंग में है तो उनको रेम्युनरेशन मिल जाएगा। अगर वर्किंग में नहीं है तो जो भी कंपनी में डिविडेंड मिलता है डिविडेंड मिलेगा, या जो शेयर्स का एप्रिसिएशन है प्राइस का, उसका बेनिफिट सारा उनको मिल जाएगा। लेकिन जो बिजनेस को रन करने की एक आर्ट है, या बिजनेस को रन करने की जो रिस्पॉन्सिबिलिटी है या जो कंट्रोल है, वो बोर्ड ऑफ ट्रस्टीज में डाल दिया। तो आपने ओनरशिप एंड मैनेजमेंट को डीलिंक कर दिया। जैसे कॉर्पोरेट स्ट्रक्चर में होता है, ऐसे ही ट्रस्ट स्ट्रक्चर में कर दिया। मैनेजमेंट इज इन द हैंड ऑफ बोर्ड ऑफ ट्रस्टीज एंड ओनरशिप इज इन हैंड ऑफ द बेनिफिशियरीज। So this is how the trust format has been developed. Second beauty क्या है ट्रस्ट फॉर्मेट में, कि within the lifetime you can pass the inheritance to your legal heirs. अगर आप विल से करते हैं तो आफ्टर योर डिमाइज, आफ्टर योर डेथ डिक्लेयर होगा कि किसके पास क्या जा रहा है। अब आपके जाने के बाद किसको क्या मिला और कौन क्या उसको वैल्यू करता है, ये किसने देखा है? इफ यू वांट कि विद इन माई लाइफ टाइम मैंने ट्रस्ट बनाया और किस किस को कितना कितना बेनिफिट देना है अपने लीगल हेयर्स में, वो स्पेसिफाई कर दिया। एट द सेम टाइम उनको पूरी एब्सोल्यूट ओनरशिप भी नहीं मिली, कंट्रोल सारा, क्योंकि अभी तो सेटलर खुद ट्रस्टी बन सकते हैं, किसी और की जरूरत ही नहीं है, क्योंकि मैनेजमेंट सारा ट्रस्टीज ने करना है। जो भी कंडीशंस आपने प्रिस्क्राइब करनी है ट्रस्ट डीड में, आपने प्रिस्क्राइब करनी है कि किस कंडीशंस पे ट्रस्टीज ने वर्क करना है और कब तक करना है। Beneficiaries may not have the power to dissolve the trust if it is so written in the trust deed. So I mean, within your lifetime, you get the opportunity or you get the privilege that you transfer the inheritance, you transfer the ownership of the assets to the desired beneficiaries or legal heirs, and still you hold the control. एक केस है इसका बड़ा एडवांटेज रहता है, क्योंकि ट्रस्ट फॉर्मेट तो दो बड़े रीजन हुए। पहला, आपने बेनिफिट्स दिए लेकिन कंट्रोल रखा, विद इन योर लाइफ टाइम खुद के पास रख सकते हैं along with some other trustees. After your death you can provide कि who will remain the board of trustees and they will keep on controlling. लेकिन बेनिफिट्स या उस इन्वेस्टमेंट से जो भी एप्रिसिएशन या फंड्स फ्लो करेंगे, वो बेनिफिट्स उनको मिलते रहेंगे आपके लीगल हेयर्स को या बेनिफिशियरीज जो भी सही करेंगे। तो दिस इज आई मीन ए ब्यूटीफुल इंस्ट्रूमेंट, बट इफ इट इज यूज्ड इन विद दैट एस्पेक्ट ओनली देन इट इज ब्यूटीफुल। क्योंकि जनरली क्या है, अगर आपने ट्रस्ट नहीं क्रिएट करते तो क्या होगा कि इनहेरिटेंस में एब्सोल्यूट ओनरशिप इंडिविजुअल्स के पास चली जाएगी शेयर्स की। अब एक कंपनी है उसमें एब्सोल्यूट ओनरशिप वालों दो, एक बेटा है एक बेटी, आजकल तो दो ही बच्चे अगर हैं, या हो सकता है एक ही बच्चा हो, 100% ओनरशिप उसके पास चली गई। अब वो अमेरिका में बैठा हुआ है, ही इज नॉट इंटरेस्टेड, वो कहेगा यार मुझसे नहीं होता, मैं तो ये शेयर किसी को दे देता हूँ। अब शेयर अगर वो किसी को बेच देता है, कौन किस तरह का बंदा आ जाता है, तो जितने बिजनेस में थाउजेंड्स ऑफ एम्प्लॉइज काम कर रहे हैं, वो जो एक सेंटिमेंट्स अटैच होते हैं सेटलर के, प्रमोटर के, जिसने इतना बड़ा वेंचर खड़ा किया है, उसको उसके लाइफ टाइम में उसके बाद कितना बड़ा हिट मिलेगा। और ही डज नॉट वांट कि ये बिजनेस जो मैंने इतना बड़ा किया ये मेरे बाद भी इस तरह से डिस्ट्रॉय हो जाए, क्योंकि इट इज नॉट ओनली द लीगल हेयर who should get the benefit whatever has been created. Rather there are so many stakeholders, जो सीनियर एम्प्लॉइज हैं, अदर एम्प्लॉइज हैं, इतने सारे दूसरे स्टेक होल्डर्स हैं, उन सबको भी आप टेक केयर करना चाहते हो. तो एक बड़ा अच्छा बैलेंस क्रिएट किया जा सकता है ट्रस्ट के फॉर्मेट को क्रिएट करके. थर्ड, कई बार जरूरत पड़ती है कि अगर जो सेटलर हैं जब इतना बड़ा काम करते हैं तो कई बार हो सकता है कि किसी इन्वेस्टिगेशन में फंस गए हों, जहां उनकी असेट्स वगैरह या उनके जो भी वेल्थ है या उनकी जो भी एसेट्स हैं या शेयर्स हैं वो अटैच होने का डर हो विद सम इन्वेस्टिगेटिंग एजेंसी. तो अटैचमेंट को रोकने का एक ही तरीका है कि अगर आपकी ओनरशिप रहेगी तो अटैच हो सकता है, बट अगर आपने ट्रस्ट में ट्रांसफर कर दिया और बेनिफिशियरीज के हैंड में जब आप बेनिफिट दे देंगे तो आपकी लाइबिलिटी अगर कोई होगी उसके अगेंस्ट में ट्रस्ट प्रॉपर्टी फॉर विच यू आर नॉट द बेनिफिशियरी, अदर्स आर द बेनिफिशियरी, देन इट कैन नॉट बी अटैच्ड. तो एक कई बार ये भी एक सिचुएशन क्रिएट हो जाती है जिसकी वजह से भी लोग ट्रस्ट को क्रिएट करना चाहते हैं. तो आई मीन दीज आर द मेजर रीजंस जो कि ट्रस्ट फॉर्मेट एक बड़ा अच्छा फॉर्मेट बन सकता है, जो कि इस स्प्लिट में और इस तरह से अगर हम क्रिएट कर सकते हैं और बनाते हैं. इसकी जो भी प्रोसीजर है, सिस्टम है, वो मनोज ने काफी डिटेल में डिस्कस किया है आपसे. और लेकिन जनरली आप लिस्टेड कंपनीज में देखा गया है ये ट्रस्ट फॉर्मेट काफी पॉपुलर है, क्योंकि लिस्टेड कंपनी मींस लार्ज कैप्स, बड़ी कंपनी बन जाती है. अब बड़ी कंपनियों में जब वो पब्लिक एट लार्ज का भी इंटरेस्ट है, अब प्रमोटर्स जो होते हैं वो चाहते हैं कि हमारे बाद भी हमारे सामने भी ये वेंचर चलता रहे, अच्छी तरह से चलता रहे और आगे बढ़ता रहे. तो जो मैनेजमेंट है वो कॉम्पिटेंट लोगों के हाथ में दे दो. अगर आपके लीगल हेयर ही इक्वली कॉम्पिटेंट हैं तो ट्रस्ट की कोई जरूरत नहीं. अगर आपको लगता है कि दे कैन रन द बिजनेस बेटर देन यू और एज यू आर रनिंग, तो कितनी जनरेशन, कितने वेंचर्स हैं जहां लीगल हेयर्स आते हैं और वो खुद ही शेयर होल्डिंग ट्रांसफर होती है और खुद ही चलाते हैं. दैट इज ओके. बट इफ यू आर नॉट कॉन्फिडेंट एनफ कि वो लोग चला पाएंगे, they are not interested or they are not competent, then trust format comes into the picture. It should be used as a very good format. दूसरा एस्पेक्ट था रिगार्डिंग टैक्सेशन. अब टैक्सेशन में देखो दो एस्पेक्ट आते हैं. पहला एस्पेक्ट तो टैक्स में आता है, पहला एस्पेक्ट आता है कि व्हेन यू ट्रांसफर द असेट्स फ्रॉम सेटलर टू ट्रस्ट, तो ट्रस्ट की असेट्स में दोनों बातें देखी गई हैं. जनरली जो अगर अपन ट्रस्ट को टेक्निकली एंड लीगली देखें कि ट्रस्ट डज नॉट, कैन नॉट होल्ड द असेट्स, शुड नॉट होल्ड द असेट्स इन इट्स नेम, रादर it should be in the name of the trustees. Trustees hold the assets on behalf of beneficiaries in trust for them. This is the technical legal concept. बट जनरली प्रैक्टिकली ये भी देखा गया है कि कई बार ट्रस्ट के नाम से भी रजिस्ट्रेशन ऑफ द मूवेबल प्रॉपर्टी और द मूवेबल प्रॉपर्टी वेस्टिंग ऑफ द ओनरशिप हो जाती है. बट दैट विल ऑलवेज रिमेन फॉर द बेनिफिट्स ऑफ द बेनिफिशियरीज. इट कैन नेवर बी फॉर द बेनिफिशियरी ऑफ फॉर द बेनिफिट्स ऑफ द सेटलर और ट्रस्टीज. ट्रस्टीज आर ओनली manage as to manage the things or to hold the assets in their name in representative capacity for and on behalf of the beneficiaries. तो एक प्रश्न तो पहले ये आता है कि when settler is transferring the assets for the benefit of the beneficiaries to the trustees or to the trust, I take both the situations. Either way, I mean treatment is the same. तो whether ट्रांसफर पर क्या सेटलर के हाथ में कोई टैक्स लगेगा, नंबर वन. उसके लिए मनोज ने कहा कि 47(3) में दे रखा है कि वहां 47(3) में ट्रांसफर की डेफिनेशन में नहीं आएगा, वहां से आउट हो जाता है. लेकिन फिर सेक्शन 56(2)(10) आ जाता है, 56(2) आता है कि जो रिसिपिएंट है, रिसिपिएंट कौन होगा इसमें? बेनिफिशियरीज. ट्रस्टीज आर नॉट द रिसिपिएंट, दे आर ओनली इन रिप्रेजेंटेटिव कैपेसिटी, दे आर ओनली इन द कैपेसिटी ऑफ द ट्रस्टी. तो बेनिफिशियरीज को बेनिफिट ट्रांसफर हो रहा है तो असेट्स उनको ट्रांसफर हो रही है थ्रू ट्रस्ट. तो उस केस में क्या उनके ऊपर सेक्शन 56(2) में 10 सेक्शन 56(2) में टैक्स लग सकता है? तो यस, लग सकता है. मनोज ने ये वाला जो पार्ट है ये मिस कर दिया था, मैं इसको यस, ये बहुत इंपॉर्टेंट पार्ट है. 56 सेक्शन 56(2) क्या कहता है? इट इज जस्ट लाइक रिप्लेसमेंट ऑफ द गिफ्ट टैक्स एक्ट जो था पहले, वो एवोल्यूश करके अब ये ले आए कि अगर विदाउट कंसिडरेशन कोई भी असेट ट्रांसफर होती है फ्रॉम वन पर्सन टू द अनदर पर्सन, देन इट इज टैक्सेबल इन द हैंड्स ऑफ द रिसिपिएंट. गिफ्ट टैक्स एक्ट जो पहले होता था वो डोनर को टैक्स करता था, डोनी को नहीं करता था. यहाँ रिसिपिएंट टैक्सेबल है, देने वाला टैक्सेबल नहीं है, लेने वाला टैक्सेबल है. और सेक्शन 56(2) में मैं काफी अब तो वाइड रेंज कर दिया है. तो उसमें कोई भी फाइनेंशियल असेट्स हैं, कोई भी मूवेबल असेट्स है, मूवेबल असेट्स है, अगर ट्रांसफर होती है देन इट कैन बी टैक्सेबल. तो इसलिए 56(2) में ट्रस्ट बनाने में टैक्सेबिलिटी हो जाएगी. लेकिन देयर इज वन एग्जम्पशन which has been given under section 56(2)(10), and that exemption is that if all the beneficiaries are relative of the settler, then it will not be taxable in the hands of the trust of beneficiaries. तो फिर सेक्शन 56(2) नहीं लगेगा, क्योंकि सेक्शन 56(2) में there is exemption if there is a transfer of assets without consideration or without adequate consideration to the relative. So whatever the definition of relative is given in section 56, अगर उसमें से, but all beneficiaries should be relative. If the trust has been created for the benefit of the relatives which are covered within the definition of the term relative under section 56, only then it will not be taxable in the hands of the beneficiaries, in the hands of the trust. Otherwise, section 56(2) लग जाएगा. So this is one point. Secondly, मनोज ने काफी डिटेल में डिस्कस किया कि ट्रस्ट की जो इनकम क्रिएट होगी, ट्रस्ट बिजनेस भी कर सकता है, ट्रस्ट में मूल प्रॉपर्टी हो सकती है, उसका रेंट भी आ सकता है, शेयर्स हो सकते हैं, उसका डिविडेंड भी आ सकता है. तो ये सब जैसे एक इंडिविजुअल के ऊपर कोई भी इनकम आती है, कंपनी में कोई भी इनकम आती है, ट्रस्ट को भी कोई भी इनकम मिल सकती है. तो अगर कोई भी इनकम मिलती है तो उसके समय ट्रस्ट की टैक्सेबिलिटी कैसे क्रिएट होगी? तो ट्रस्ट प्राइमरीली दो तरह के हो सकते हैं, रिवोकेबल, इररिवोकेबल. अगर रिवोकेबल है तो ये मानो कि एक ट्रस्ट बना ही नहीं टैक्स के एंगल से. फिर तो जो सेटलर को जो टैक्सेबिलिटी है उसकी टैक्सेबिलिटी असेट्स की सेटलर के पास ही रहेगी, ट्रांसफर हुई नहीं असेट्स, क्योंकि रिवोक अगर कर सकता है, वो पावर रखी हुई है, तो सेक्शन 61 में इनकम टैक्स में प्रोवाइड कर दिया. अब हो सकता है इररिवोकेबल. इररिवोकेबल में दो तरह के ट्रस्ट हो सकते हैं. वन इज डिस्क्रिशनरी, जिसमें कि शेयर ऑफ द बेनिफिशियरीज इज नॉट स्पेसिफाइड, कि अगर 8 बेनिफिशियरीज हैं तो किसका कितना कितना शेयर होगा वो स्पेसिफाइड नहीं है, टोटल बेनिफिट्स होंगे. अब वो ट्रस्टीज के ऊपर या ट्रस्ट डीड में जो लिखा हुआ है उसके हिसाब से बेनिफिशियरीज को बांट दिया जाएगा, या ट्रस्टीज का डिस्क्रिप्शन हो सकता है कि वो किसको कितना बेनिफिट देना चाहते हैं. तो ये नहीं मालूम कि किस बेनिफिशियरी को क्या मिलना है. तो अगर डिस्क्रिशनरी ट्रस्ट है तो उसका मतलब ये हुआ कि उसको फिर हम बेनिफिशियरीज के हैंड में टैक्स कर नहीं सकते, और उसका कुछ डिटर्मिनेशन भी नहीं है. तो ऐसे केस में ट्रस्ट की जो इनकम होगी तो वो ट्रस्टीज के हैंड में या ट्रस्ट के हैंड में ही टैक्सेबल होगी, और मैक्सिमम मार्जिनल रेट से ही टैक्सेबल होगी, चाहे वो बिजनेस इनकम हो चाहे कोई दूसरी इनकम हो, मैक्सिमम मार्जिनल रेट भी उस पर लगेगा. लेकिन अगर डिटर्मिनेट ट्रस्ट है, स्पेसिफिक ट्रस्ट या डिटर्मिनेट ट्रस्ट बोलते हैं उसको, उसका मतलब क्या होता है कि बेनिफिशियरीज का जो शेयर है कि किस बेनिफिशियरी को कितना बेनिफिट मिलेगा आउट ऑफ द असेट्स और कॉर्पस और द इनकम ऑफ द ट्रस्ट, वो स्पेसिफाई किया हुआ है. तो यहाँ अब सिचुएशन ये हो गई कि ऐसे केस में टैक्स के एंगल से अगर हम ये कहें कि ट्रस्ट को टैक्स प्लानिंग के एंगल से क्रिएट करना है, इट हैज गॉट नो मीनिंग. टैक्स प्लानिंग के एंगल से ट्रस्ट क्रिएट करके हम कोई अच्छी प्लानिंग कर पाएंगे या टैक्स की सेविंग कर पाएंगे या लॉन्ग टर्म में कोई बेनिफिट कर पाएंगे इन द हैंड्स ऑफ द सेटलर और बेनिफिशियरी? नॉट एट ऑल. सिचुएशन रिमेन्स द सेम, जैसे विदाउट क्रिएटिंग ए ट्रस्ट है ऐसे आफ्टर क्रिएटिंग ए ट्रस्ट है. अगर बेनिफिशियरीज स्पेसिफिक ट्रस्ट है, बेनिफिशियरीज का जितना शेयर है, तो उसमें दोनों ऑप्शन है, या तो बेनिफिशियरीज उस इनकम को अपने रिटर्न में दिखा देंगे और उसके ऊपर टैक्स पे कर देंगे. देन ट्रस्टीज in representative capacity or trust are not required to show that income. वो अलग से टैक्स पे नहीं करेंगे. और अल्टरनेटिवली व्हाट कैन बी डन कि बेनिफिशियरीज ना दिखाएं अपने हाथ में, ट्रस्टीज इन द रिप्रेजेंटेटिव कैपेसिटी फॉर बेनिफिशियरी में फाइल द रिटर्न, लेकिन उसकी जो टैक्सेबिलिटी होगी वो इन द सेम मैनर एंड टू द सेम एक्सटेंट होगा जैसे बेनिफिशियरीज का हुआ है, इंडिविजुअल बेनिफिशियरीज का हुआ है. तो हर इंडिविजुअल बेनिफिशियरी के लिए रिप्रेजेंटेटिव कैपेसिटी में हो सकता है अलग अलग वो रिटर्न सबकी फाइल करनी पड़ेगी. that can also be done. So from tax angle, it is only a procedural thing. जो section 164 में दिया हुआ है कि कैसे रिटर्न फाइल करनी है, but from the tax angle, हम अगर ट्रस्ट को टैक्स प्लानिंग एंगल से क्रिएट करना चाह रहे हैं, then I don't suggest कि this is a good instrument and one should venture for this. But the earlier points which we discussed are very very important. और जहाँ बड़ी स्टेक कंपनीज होती हैं और जहाँ वो जो सारे कंसिडरेशन हमने मनोज ने मैंने आपको 4-5 चीजें इंपॉर्टेंट बताई कि उन चीजों को देखते हुए ट्रस्ट का फॉर्मेट क्रिएट करना और ट्रस्ट इंस्ट्रूमेंट को क्रिएट करना बहुत इंपॉर्टेंट हो जाता है. एक और बहुत बड़ा रीजन है जो कि अभी इंडिया में नहीं है लेकिन बाहर के कंट्रीज में बहुत होता है, इनहेरिटेंस टैक्स. यूएस में हैवी इनहेरिटेंस टैक्स है, मोर देन 50%. तो इंडिया में अभी इनहेरिटेंस टैक्स नहीं है. तो अगर आप ट्रस्ट अपनी लाइफ टाइम में क्रिएट करके बेनिफिशियरीज को ट्रांसफर कर देते हैं तो इनहेरिटेंस नहीं होती आफ्टर डेथ. तो इसलिए इनहेरिटेंस टैक्स नहीं लगता क्योंकि ऑलरेडी एट दैट पॉइंट ऑफ टाइम असेट्स हैव बीन ट्रांसफर्ड टू द बेनिफिशियरीज और टू द ट्रस्ट. उसकी जो भी टैक्सेबिलिटी अगर होगी, जैसा हमने ऑलरेडी डिस्कस किया, वो उसी समय हो जाएगी. एट द टाइम ऑफ डेथ कोई इनहेरिटेंस नहीं होगा. लेकिन इंडिया में चूंकि अभी इनहेरिटेंस टैक्स नहीं है, इसलिए ये ट्रस्ट को इस पॉइंट ऑफ व्यू से क्रिएट करना अगेन नॉट एडवाइजेबल. आज से 4-5 साल पहले एक बड़ा फैशन आया था इंडिया में, क्योंकि काफी रूमर आई थी कि इनहेरिटेंस टैक्स आने वाला है, और ये अभी भी कई बार आती रहती है कि इनहेरिटेंस टैक्स आने वाला है. तो इसलिए लोगों को लगता है कि ट्रस्ट बना लो. तो अगर वाकई में इनहेरिटेंस टैक्स आता है तो ट्रस्ट विल बिकम ए वेरी गुड इंस्ट्रूमेंट फ्रॉम टैक्स प्लानिंग पॉइंट ऑफ व्यू. बट टिल नाउ इट इज नॉट देयर. And keeping in view the tax structure in the country, the social fabric of the country, and the long-term tax policies of the government, and the play of the gift tax, wealth tax, and the inheritance to the relative, etc. If I look into, I don't see that in near future inheritance tax may be introduced in India. I don't see, because it has to be in consonance with all other parameters and which may the other offshoots which may be created out of this inheritance tax. So keeping in view particularly the social fabric of the country, I don't think that this tax is advisable. It is suitable to our country. I think in a nutshell, Manoj, it is good enough. Ankit, I have tried to explain all these things, and I have to leave also at 5 o'clock because I have to attend another program on CSR. If in case, before I leave, in case there is any query which you want to address to me, I can give another 5, 7, 8 minutes. Otherwise, you can carry on, please. Thank you.
A small question. You talked about Section 56 impact on transfer of assets, and there is an exemption when there are only relatives. What if post transfer of assets at that point of time they are relatives, but post the transfer of assets additional beneficiaries are added to the trust deed and they are not relatives? So whether there will be any tax implication because the asset has already been transferred?
The assets which have already been transferred at that point of time when beneficiaries were relative, taxability is not there. But later on, if beneficiaries are added, then this will have to be examined. But to my mind, Section 56 will become applicable.
Otherwise, it will leave a very...
Otherwise, one can plan the things like this.
One can very...
So 56 will become applicable at that point of time.
And another important point...
But I am not still sure whether that taxability will be proportionate or it will be full. I have tried to examine this issue, but I could not reach to the conclusion. मैंने आज सुबह ही देखा इस चीज को कि for example 80% relative है, 20% beneficiary non-relative है, तो taxability 20% के extent पे होगी, या क्योंकि जो language है 56(2)(10) में वो है it is for the sole benefit of the relatives. तो उससे तो impression ये निकलता है कि 100% relative होनी चाहिए. But again, we will have to look into deeply this issue, whether this can be proportionate or this can be in total.
And another important point that you mentioned, that while there is a general awareness that succession planning through trust is mostly, while there are other administrative benefits associated with it, is on account of tax planning. But you mentioned that tax planning is per se not much beneficial in case of trust. So in terms of tax impact, if I hold the property in my own name or if I transfer it to a trust, so net tax impact, there will not be much of a difference. As
Yeah,
per you.
not at all, because the basic principle is that the tax is to be imposed in the same manner and to the same extent as to the beneficiaries. When this is the underlying principle on which the entire section has been created, entire tax principles have been created, then I mean, from the point of view of tax benefit may be when inheritance tax comes into the picture. And as soon till inheritance tax is not there, I don't think there is any advantage one can derive so far as the tax planning aspect is concerned.
Okay. So thank you, sir. Thanks for your time and sharing important aspects of succession planning through trust. I'll welcome Mr. Rakesh Arora, who is the senior.
I may leave, Ankit. Okay,
Sir,
thank you.
If you can stay and can contribute in parts, that would be great. I understand you have a
yes, I have to leave because I have another program at 5:30 today. I have to go there.
So thanks for your time.
Okay, thank you very much.
So I welcome Mr. Rakesh Arora, Senior General Manager at Corporate Affairs at Subros Limited. And I believe Mr. Sanjay was also there. He has left, I think, for some specific work, and he would be joining us soon. So Rakesh ji, if you can switch on your video, if possible.
Yeah. Good evening, everybody, and thank you for placing me on this webinar. So I will, Ankit, Shivam, can you please make it quick because I am out of.
Yeah,
actually, I am out on the road, so I can help you wherever for 10 minutes I am available. So
okay.
Can we make it quickly? Yeah.
So Mr. Arora, thanks for joining. So we want to hear your experience in terms of succession planning, if through trust, if any you have at Subros, and benefit and impact that you feel has that structuring has made.
Yeah. Mr. Manoj and Mr. Agarwal has given a very lucid pointers on the various aspects like taxation, formation of the trust. Now I would just like to add here that the process is very simple. The only difficult area is the structuring of the trust, because every family, every promoter has a different view. So that is the area where a lot of discussions and basically inputs are required from each of the promoter side, or who is giving the settler, I would say. So that is one point which takes a lot of time. So once there is a clarity from the promoter about how to structure the trust, then as well as the formation of the trust, if there is a immovable property in the trust, then it has to be registered. It's a pretty simple document. Any deed writer can define that. And though it is not mandatory for the immovable properties like shares and any other movable properties, but yet from the income tax perspective, it is always suggested that one gets the trust registered here also. So the only difficult question for the promoter is whether he should have a discretionary trust or a non-discretionary trust. So this is the key area where the promoter always get confused, because ultimately it is the succession planning which they are doing right now during their lifetime. So the main advantage of getting the trust, as elaborated by Mr. Manoj also, is that during the lifetime, the settler can create a suitable structure. Then a lot of differences can be settled during his lifetime. The settler also has good confidence over his family that, okay, I am passing to the transgenerational, my assets, whatever I have created during my lifetime. And then also the plus point is that during his lifetime, he can also terminate or close the trust. Means we can have a time period of the trust also, maybe for 10 years, 15 years. And then the assets can be given to the beneficiaries. And also the beneficiaries are very clear as to what they will get. So the disputes also gets reduced to the extent that after passing away of the promoter, generally there are disputes, legal cases. So here everything is crystal clear as to who will get the assets and in which ratio. So as far as the trust document is there is nothing much. The only difficult area is for the promoter to define the succession structure, how they will pass on the assets to whom, which proportion.
Okay. Mr. Arora, do you feel promoters face resistance from the family in case they want to create a trust structure where the benefit, the ownership will be in the name of the trustees or trust, not the family owners? So any resistance that is there from the family members, you foresee such a case?
See, generally, firstly, the main promoter or the settler who is giving the assets. So first, if he has the clarity, then also see every family has different permutation combinations, right? So as Mr. Agarwal also said, one son is here, one son is settled outside India. There are multiple businesses, or there is a single business with multiple sons. Maybe they don't have son, they have only daughters. So many things are there. So this is a new area where people are coming in, and also now a lot of big fours are poaching large industrial houses. So this is very common in the western part of India, mostly in Bombay-based companies like Godrej, what we have studied. They have created a very transparent structure since beginning. So generally, if one promoter or one family has done the trust structure, so automatically it passes on to the others. So as far as the structure is fair to the family, then there are no major resistance.
Okay. Any specific advice while you draft the trust deed in such cases?
See, in the trust deed, there is an annexure where the assets are basically distributed. So in case one structure could be that you are distributing, you specify the beneficiaries, and then you mention that all the beneficiaries, suppose there are 4 beneficiaries, so all beneficiaries will get equally 1/4, right? So there is nothing much you can write in the trust. There is no need to define all the assets. But in case you want to define or give or pass on the assets based on each and every individual line item, then you need to specify each and everything in the trust through an annexure that can be done.
Okay. Any other point that you would like to share, Mr. Arora, out of your experience?
See, nowadays, as Mr. Agarwal also said, the trust is basically about 60% trusts are made based on some kind of a urgency or maybe some tax matters getting stuck up, right? So to take care of those, one can do. And one good point is that you can add minors also in the trust as a beneficiaries because they are also immediate relatives. So that is also a good point to add minors also to the trust so that you can pass on the assets to the second generation also.
Okay. Thank you.
Okay, thank you. Thank you very much.
Now I'll request Mr. Ravi Prakash to share some key points that one should keep in mind while drafting the trust deed. Because fundamentally, like memorandum and articles in a company, trust deed is the charter document for the trust, and that defines the manner in which the trust will be run and operated. So therefore, it is very important that trust deed should be very carefully drafted to avoid any issues or conflicts later on. And key provisions with respect to appointment of trustees, their removal, because trustees are these persons who manage the trust, and they are the sole power bearers of the trust, while beneficiaries receive the benefits, but ultimately they are the person who manages their trust, and are very stronghold position in respect to the trust. So while drafting the trust deed, there are certain points that one should keep in mind. So I'll request Ravi to share his views on the same.
Thank you so much, sir. Very good evening to all in the audience and all on the panel. And I remember that Manoj sir said in his plenary speech that it's very difficult. Perhaps the most difficult part is to customize, make a bespoke design of trust suiting the structure. And the same was echoed by Mr. Arora and then Dr. Agrawal. It is certainly a very dynamic concept. There is no one size that fits all, and there is no one remedy that can resolve all problems. But there are some key considerations which, while formulating or setting up a private trust from the perspective of succession planning, one may keep in mind. And not only in mind, one must also reflect it fairly well on the papers. Number one is defining the object and term of the trust. That's number one. Secondly, the trustee lineage. Who shall become trustee in the trust? And how the decisional matrix or delegation of authorities would be done. That should also be clearly delineated. By this I mean that because in family businesses, in India particularly, there are multiple factions. It is not the case that only one generation is working. There could be multiple generations and multiple factions working at the same time and all looking after different areas, which are all crucial to the business. So therefore, considering the particular or peculiar situation, one must focus on how the administrative machinery, not at the trust level itself, but also pertaining to the family business, how that machinery will be operated through trust. Code of conduct is a buzzword which we all must be listening, that there must be a code of conduct. So this facility of code of conduct can also be laid down through the trust, in which not only the administrative but also the behavioral and commitments are laid down for the existing generations and the generations that are forthcoming into the business. Third is policy for distribution of the corpus and income from the trust. This can be delineated subject to the decision whether the purpose is to keep trust determinate, which is also known as a specific trust, or it can be left discretionary. Now, we have discussed about discretionary trust in the beginning of the session. These kind of trust, let me give you a handy example to understand. Supposingly, in a large family business, there are a lot of unmarried sons and daughters of the entrepreneurs. So they usually create a trust for marriage and settlement of their progeny. This is a type of trust where you do not really enunciate how much would be spent or how much would be allocated for whom, and it is left to the discretion. So this is discretionary trust where the interest is not determined. In distinction to this discretionary trust, there could be determinate trust where the mainstream income is distributed, or the proceeds from the assets or businesses being managed by trust are distributed or appropriated. There, specific trusts have major role to play, and in few cases, it is not that you have to only keep a trust in specific or determinate form. Mix of both can also be done. Few aspects specific and few aspects discretion. Veto powers. Out of my first-hand experience, we've seen that because settlers and trustees, in fact, in private trust, particularly created for succession planning, they do not keep all the trustees at same footing. There are trustees who are vested with special powers. So this can be one of the considerations, that if really the objective is to secure the posterity of family, there could be trustees or an advisory board or a protector who is clearly in an advisory role, who would consult with trustees and may have special veto powers. Now, because and I bear a different perspective on whether trust deed is just like memorandum and article, or it is something more than that. Let us see the different perspective of what a trust deed as an instrument creating the trust could be. As per the laid down precedents and established principles, a trust deed is no better than a contract or agreement. Because the Trust Act, which largely governs the private trust, is akin to Contract Act, which does not lay down all what you can do under the law, but only lays down the contours. The Trust Act also functions on the similar principle. It's an enabling law. So therefore, what is written in the trust deed is essentially what is the power and administrative machinery of the trust. So the duties of the trustees, rights of the trustees, their removal, their admission, the powers, how they will exercise the powers, whether they need to consult, what decision with an advisory board or a protector, what kind of decisions would entail unanimous decisions, any specific majority of decisions. These things should be clearly delineated. And as for the beneficiaries, their rights, duties, their power, their interest in the subject matter, and their participation, all these things must be clearly delineated. These are the major broad contours what should be delineated in the trust deed. Apart from this, and these are because trust deed, laying down a trust deed is more of a work of an art. So there are probably from Western jurisprudence a lot of concepts that are being borrowed. Now there is a concept of letter of wishes, because it is the settler who is reposing this confidence in property for managed for the beneficiaries. Settlers also issue, or they can issue letter of wishes to the trustees, and this is a private letter. This is a private instrument between the trustees and settlers, whereby they do not make the trust determinate, but they issue persuasive instructions to the trustee with respect to crucial aspects of the management of the trust. There can be policies that can be laid down in the trust deed. If the business or the underlying business requires some kind of policies to be laid down for ensuring discipline, or as I said earlier, a particular code of conduct for running of the business. So that is broadly what can be considered as the key characteristics or key pointers which one should consider while drafting a trust deed. And last but not the least, it should be kept as unambiguous as it can be. And the terms should be really simple and easy to understand, which are used in the trust deed, because there is no gainsaying and making an internal document for the benefit of family so complex that they are not even able to understand it. So that is all, I think, simply put.
So, Ravi, as you mentioned that trustees is akin to a contract or agreement, is there any possibility that the beneficiaries can file a suit against the trustees if they act in breach of the covenants of the trust deed?
Yes, very much. In fact, Section 13 and Section 26 enjoins statutory duties on the trustees, and these duties are to they bound trustees to deal with the trust property as any reasonable person would deal with his own property, and to safeguard the trust property. So if the trustees are not able to safeguard the trust property or apply it for the best of the purposes, to the best of their ability, which is always tested on the anvil of reasonableness, the beneficiaries can sue. But interestingly, as an extension of your question, an issue arose recently before Supreme Court in 2016 in matter of Vimal Shah versus Jayesh Shah. The question was whether beneficiaries can also sue the trustees in arbitration. Can they take them into arbitration? The logic was that because beneficiaries are the ultimate, you may say, ultimate beneficial holders of the trust, and because they are joined by the umbilical cord of trust and settler, and these trustees are acting for them, they can take the trustees in arbitration. But ultimately, Supreme Court was of the view that no, that cannot be done. They are not signatories to an arbitration agreement. And even though trust has an arbitration agreement, beneficiaries cannot take trustees to arbitration. But as far as the right to sue them, yes, they have specific rights in the Trust Act to file a suit in civil courts.
Okay, thank you. Thanks for the details, and I'll come back to you in the Q&A section. So now moving on, I welcome Ruchika Sharma. One of the fundamental issue in case of succession planning, and primarily in case of listed entities, is the transfer of the property from the promoters to the trust. And as we are all aware, in case of listed entities, takeover code plays an important role as and when there is any change in the shareholding of the promoters, even inter se or transfer to some other person. And therefore, it is very imperative that we need to take in account the implications of takeover regulations while we are planning any structure where shares are to be transferred in the existing trust, or to a new trust from the promoters or other persons forming part of the promoter group. So Ruchika will share her views as to the implication of takeover regulations in such situations, and how we need to plan and proceed when we want to structure a transaction like this. Over to you, Ruchika.
Thank you, sir. Thank you very much. So, as you have briefly mentioned that there are cases when the individual promoters intend to transfer their individual holding to the trust, to a private trust, and then at that point of time, takeover regulation will come into play. So, to cover the critical aspects of takeover regulations, I would be discussing the main reasons and why the exemption is being sought under takeover regulations to claim exemption from open offer. So as Mr. Manoj and Mr. Agarwal has mentioned in the initial presentation, the broad reasons of why private trusts are being formed and why promoters are transferring their shares from individual holding to a trust, we need to understand that why the takeover regulation get attracted. So prior to coming to the point that why there is a triggering of open offer and why there is no automatic exemption available to them, let us understand the trigger events under takeover regulation provided to the persons who are holding shares. So under regulation 3.1, the initial trigger is at 25%, which states that if any person who acquires or who triggers the benchmark of 25%, then the open offer shall be made. While calculating this 25% threshold, the shares already held by such person along with PAC need to be taken into consideration. Another regulation 3.2 come into play when the promoter and promoter group are already holding beyond 25% but less than 75%, and if they acquires additional shares of 5% or more in a financial year, then the open offer shall be made by such persons. But interestingly, when the shares of individual promoters are transferred to a private trust, aggregately there is no change in the shareholding of promoter and promoter group. All exemption applications or all triggering of open offer arises because of regulation 3.3, which says that you need to check the threshold of 3.1 as well as 3.2 on individual as well as aggregate basis. So let us take an example. If the entire promoter and promoter group is holding 40% in a company, and Mr. A is holding 23%, and Mr. B is holding 17%, and Mr. A acquires additional 3% shares in a company, which increases his holding from 23% to 26%, then the open offer would be attracted under Regulation 3.1, read with Regulation 3.3. Apart from the numeric thresholds provided under takeover regulations, there is a trigger event which arises upon acquisition of control. Now, what Regulation 4 says about control is that when any person acquires control by virtue of acquiring right to appoint majority of directors, or right to control the management, or right to control the policy decisions, either directly or indirectly by virtue of their shareholding or management rights or voting agreements or any other agreement, because this definition is inclusive in nature. So there can be a lot of things which is not covered under law as of now, but would tantamount to give a person a controlling position in a listed company, then Regulation 4 would be attracted. Now, considering these trigger events, it is apparent that if some person is introduced in the promoter and promoter group, or if some person acquires shares in the promoter and promoter group, then open offer obligation would be attracted. While the capital market regulator SEBI, when framed this law, they foresee in certain instances where open offer should not be made, and there should be some automatic exemptions available to the open offer obligation. So today, since we are discussing the transfer of shares from individual promoter to private trust, let us understand whether there is any automatic exemption available to private trust under Regulation 10 from the open offer obligation or not. So there are a lot of instances covered under Regulation 10 which provides for exemption from open offer in cases of right issue, bonus issue, or pursuant to scheme of arrangement. But we are specifically focusing on three major relevant provisions, where we could imagine that, or we could guess that the exemption is available to the trust. Number one is interstate transfer of shares amongst immediate relatives. Number two is interstate transfer of shares among promoters who are already holding shares in the company for the last 3 years in the shareholding pattern. And number three is interstate transfer of shares among group companies. So whether a private trust would be exempted under Regulation 10(1)(a), which says that exemption is available to immediate relative. For this, we need to check the definition of immediate relative under takeover regulation, which says that immediate relative means any spouse of a person and includes parent, brother, sister, or child of such person or of the spouse. So here it is clear that trust automatically is not covered under the definition and is not exempted. Then coming to the next provision, which says that any person who has been disclosed as promoter in the shareholding pattern in last 3 years, then such person would be automatically exempt from the obligation of open offer. Now, before coming to the point of disclosure, let us first understand whether the private trust can be a promoter of a listed company or not. So under takeover regulation, the definition of promoter is referred back to ICDR regulation. When we go to ICDR regulation, the definition states that the promoter shall include a person who has been named as such as promoter in the offer document or is identified as promoter in the annual return filed under Section 92. This is the first condition. Second condition is a promoter is a person who has control over the affairs of the company. And the third condition is a promoter is a person on whose advice or directions the board is accustomed to act. So now, considering all these conditions, it can be understood that while incorporating a company, if a private trust is inducted as promoter at that point of time, is mentioned as promoter in the offer document at the initial stage, or has control from the very beginning, then probably that trust would be exempted and that trust can acquire shares as a normal course of action as promoter does. But at a later stage, this is not the case. So now to understand it better, we went to the definition of promoter group. it is obvious that in any listed company there can be 1, 2, 3 promoters, but there can be several persons or entities who are connected to those promoter, but who are not shown as promoter or promoter group in the shareholding pattern because they're not holding any shares in the company. So when we check the definition of promoter group, we analyze that body corporate, holding company, subsidiary company, or even HUF was covered in the definition, but nowhere trust was mentioned in the definition. So it clearly showed that there was no intention of lawmaker to consider trust automatically as member of promoter or promoter group in listed companies, and there should be specific process of bringing that private trust on the promoter and promoter group under takeover regulations. So it can be concluded that the exemption is not available under regulation 10(1)(a)(2) as well. Now we analyze the third case, which covers the interstate transfer exemption under group companies, which specifically says that the exemption is available to a company, its holding company, its subsidiary company, other subsidiaries, a person who is holding 50% in one company and controlling the main company. All the group companies can be exempted. And the term used in this clause is specifically body corporate. While analyzing the definition of body corporate under takeover regulation, it was specifically mentioned that it can be Indian as well as foreign. And when we went to the definition provided in Companies Act, it again does not cover the term trust in the definition. So the automatic exemption to trust was not even available in this clause also. So considering when a private trust has to acquire any shares in a listed company, then the only route available to the private trust is to seek exemption under regulation 11, where you have to file application to SEBI. SEBI will analyze the grounds, will check on your facts, and then will provide exemption to the private trust to acquire shares in a listed company. Now, since 2016, SEBI has analyzed that a lot of applications were being filed to SEBI to seek exemption. Maybe because of tax planning, maybe because of some other reasons, whatever at that point of time, the family trusts were created and the exemptions, the applications were filed. So considering to faster process the application, SEBI came out with a circular in December 2017 providing certain conditions which, if complied, then the exemption would be provided on a faster basis. So certain conditions in that circular was that the trust should be only the mirror image of promoter holding, and there shall be no change in the ownership or control of the target company post to the acquisition of shares or control by such trust. Only individual promoters or their immediate relatives or lineal descendant should be the trustees or beneficiaries of such trust. The beneficial interest of the beneficiaries of the trust shall not be transferred, assigned, or encumbered in any manner in future to any other person. In case of dissolution of trust, the assets shall be distributed only to the beneficiaries or to their legal heirs. And the trustees shall not be entitled to transfer or delegate any of their powers to any person other than amongst themselves. So these were the broad or the key conditions which SEBI circular provided, and if are met, then probably the chances of getting the exemption would be more in comparison to other cases. There were certain other undertakings which were also required while seeking the exemption, which were that in case of change in trustees, beneficiaries, or any change in the ownership, you need to disclose such change within 2 days to stock exchange and SEBI, or the ownership or control will be treated as vesting only to the trustees, but also indirectly with the beneficiaries. The liabilities and obligation of individual transferor will not change or get diluted due to transfer of any trust. And the trust shall confirm on annual basis that it is in compliance with the exemption order given by SEBI, and that compliance shall be disclosed in the shareholding pattern while filing done under LODR. And the trust shall get its compliance certificate certified from independent auditor annually and furnish the certificate to the stock exchange and SEBI. Certain other conditions were that the trust shall be in compliance with the Companies Act provisions, and the transferors who are transferring shares to the private trust should have been disclosed as promoter in the shareholding pattern in last 3 years, and there shall be no layering in terms of trustees and beneficiaries in case of trust. And the trust deed agreement does not contain any limitation of liability of trustees, beneficiaries in relation to provision of SEBI Act and all other regulations framed thereunder. So once you review the conditions, it clearly states that SEBI is of the view that exemption should only be provided when the benefit is transferring only to the immediate relative or the lineal descendants of the promoters, and there is no change, there is no further change of control to some other person or some third party in future. So then only the exemption would be granted. Assuming if there is any change, then you have to report to SEBI, and I'm sure they'll come out that you have to give an open offer for transferring such benefit to any other person. So when we went through the annual report of SEBI, we found that since financial year 2016-17 till financial year 2021, SEBI has disposed nearly 178 applications under Regulation 11 of takeover regulations, and out of 178 applications, approximately 75 cases were of acquirers being trust acquiring shares in the listed companies. So while analyzing the cases, most of them were complying with the conditions which were provided in the circular, and most of the cases were plain, simple, vanilla cases. But there were certain cases where we found that the companies have inducted trust as promoter with very minuscule holdings, say 500 shares or 100 shares, and thereafter they have applied to SEBI for seeking exemption upon acquisition of substantial shares, which, considering the legal position, should not be the case. So broadly, these are the frameworks. This is the procedural aspect of how you can seek exemption under takeover regulations. And while framing your trust deed, all these conditions or covenants which are provided in SEBI circular should form part of your trust deed, because it would, then at a later stage you need not to make changes in the trust deed. So considering these aspects, I think whosoever is planning to create a private trust and transfer their holding, they can get the SEBI approval in a very faster and easy manner. Thank you very much.
You talked
Yes,
about seeking exemption when the trust is not shown as part of the promoter or promoter group.
Right, sir.
What if the trust is already part of the promoter group disclosed in the offer document or in the annual return, and then one of the promoter or group of promoters seeks to transfer their holding to that trust? In that case, will this exemption will be required, or there is some mechanism that needs to be followed?
So then probably they'll fall into the bracket of Regulation 10 if already disclosed for 3 years, and they will automatically be exempted and reportings would be done. No separate application should be filed under Regulation 11 for seeking exemption.
As Ruchika has already said, in case of promoters, if the person is disclosed as part of the promoter group for continuously 3 years, then there is no requirement of seeking exemption. And in this category, there is no requirement of class, what kind of person he is, or what is the relationship between those persons. So they may be totally unconnected or different group of persons and making transfer inter-se among themselves. If the conditions are getting fulfilled and the period of 3 years has already elapsed, then there is no requirement, no difficulty in seeking the exemptions.
And in such case, who is treated as promoter, the trustee or the trust?
Trustee, basically the trustee acting through trust.
Okay.
Obviously, the ownership will remain with the trustee only, not in the hand of the trust. Trust is not a legal entity.
Yes.
Because while we have earlier, there was understanding that in case of trust, only the trustee can hold shares on behalf of trust. But these days, the depositories are also opening the demat account in the name of trust itself.
Mm-hmm.
In this case, the shares.
It is just a matter of name. It is not the ownership. Yes, because the trusts are taxed separately and they get the PAN number. So demat account opening is not difficult. Demat account or bank account opening is not a difficult. But It will be just a face, and the ultimate person will be the trustee, not the trust.
Okay. Thanks, Ruchika. Thanks for your insights on this important topic. So now let's begin with the Q&A. We have received some queries prior to the program and during the course of the program. So I'll post the queries one by one to each of you, and we'll hear your insights on those. So starting with Manoj, query is whether family trust is permitted to invest in securities market or FNO market. Can they invest?
Yes, it is a very common thing. There are many of the family offices running in the form of trust. So trustees on their behalf keep investing in the capital market, acquire shares or FNO or futures and options, and that is totally allowed if it is permitted under the trust deed. So trustee has to govern through the trust deed. If the trust deed allows, he can do it.
Okay. Moving along, Ruchika, this is a little detailed question. When shares in a listed company are transferred to a family trust by promoters, there is obviously no increase in the total promoter stake. Regulation 3 sub-rule 3 will get attracted. But question is, when transfer to trust is less than 5%, where existing promoter holding is already more than 25%, whether such transfer of less than 5% will be accounted for calculating the creeping limit or not?
For creeping limit, I would say no, but the trigger will happen under Regulation 4. As I already mentioned while giving my presentation, that you cannot induct any person in the promoter and promoter group without going to SEBI, because that person is not disclosed in the definition of promoter or either in promoter group. So exemption should be filed under Regulation 11 from Regulation 4 of open offer.
So where this transfer creeping limit, then it will be deemed the creeping limit for the promoter individual who has transferred, or the trust once it seeks the exemption?
Sir, once they'll take the exemption, then the creeping limit would be applicable for such private trust, along with the all persons who are not selling to that private trust, because they will form part of pact to the private trust, and the person who is selling would be treated separately.
So, may I add that in case we seek an exemption or give open offer, that transaction is excluded from the limit of creeping limit of the year.
Yeah,
so
yeah,
let's say a promoter is transferring 3% share to a trust, and for that he has already taken exemption in Regulation 11. Then this 3% would not be counted for the purpose of creeping limit of that financial year. But from the next financial year onward, this trust would also be forming part of the promoter group, and the collective threshold of 5% would be applicable.
Okay.
Correct.
Thank you, Ruchik and Manoj. So Ravi, the question is, can will be totally eliminated in case of settler of the trust?
Will, you're asking, can will be totally eliminated? No, I think no. Trust is not for the purpose of eliminating a will. It is for supplementing a will. So in fact, will is a very good instrument. If you couple it with the private trust machinery and use it, it will be very beneficial. So no, anytime soon, will is not going out of the regime.
I think will, if entire property is settled through a trust and as part of the this testamentary trust, then there may not be a need to probate the will and then distribute the assets, because the beneficial ownership will automatically get passed to the trust, and then trust would distribute or continue to hold the assets for the benefit of the beneficiaries. So in that case, there may not be a need to form a will, but it is not a substitute to the will. It is two are different things.
So Manoj, next question is for you. The subject of stamp duty applicability on transfer of shares of private companies into private trust, and whether there will be any relief if such shares are dematerialized rather than physical. Although stamp duty is a state subject, but a general discussion would be helpful. Apparently, in particular, with respect to West Bengal, this transfer would fall under settlement, where the concessional duty with respect to dematerialized share would reduce the burden of 4% applicable on settlement. So West Bengal will be very too specific for you to answer. But any exemption on transfer of shares to a private trust from stamp duty?
No, stamp duty perspective, there is no exemption. In fact, there is a specific duty applicability, and in case of obviously transfer of shares, it is not a state jurisdiction, it is the central jurisdiction. In case of demat shares, there is a specific rate of duty which is recently prescribed, that is 0.15%, 0.15% of the value of the shares being transferred. In case of non-demat shares, the transfer duty is 0.25% of the value of the shares, so that would be applicable.
I think that transfer duty has changed pursuant to the recent amendment. So it will.
What is that?
I think it's 0.005 something or 0.015.
Even for physical shares?
Not for physical and dematerialized shares. So
Okay.
Another detailed question for you, because since it's matter of listed entities, so some have shared their question in detail. So promoter group holds more than 50% shares in a listed company. Promoter group includes one body corporate which holds less than 5% shares in the listed company in its name for beneficial interest of its partners. Their said body corporate being one of the partners. Another partner who is an individual promoter intends to transfer his partnership interest to a newly family trust. The voting rights would continue to be exercised by the said body corporate partner. There is no change in the voting. Whether you feel would attract any provisions of open offer under Regulation 3 sub 2.
Again, I think if the shares, you said shares they are holding is less than 5%, right? So if a family trust is introduced in a partnership firm and that is pursuant to transferring of more than 50% partnership rights in that particular body corporate, then that trust will have voting rights over these whatever percentage shares. So again, Regulation 4 will come into play, not Regulation 3.2. This is a common confusion around the industry.
Another question is, what if the change in the shareholding, transfer of shareholding is not happening at the promoter company, but at its holding company, and that holding company is transferring its shareholding to a trust, whether that would have implications under the takeover regulations?
Sir, there is no concept of proportionate holding structure for, considering the voting rights. So whosoever is the ultimate beneficial owner, if there is the change in ultimate beneficial owner, then probably Regulation 4 will be triggered, I would say, to just briefly summarize it, although it was a very long question.
So Ravi, for which purposes trust is considered to have a separate legal entity? And for a separate legal entity, it is mandatory to register the trust?
First of all, I would start the last part first. It is not mandatory to register all kinds of trust, only if an immovable property is bestowed upon the trust and the value is more than 100 rupees, because it is an act of 1882. Value is still 100. Although you would never get an immovable property for rupees 100 today. But if that is the case, then registration becomes mandatory, but it is advisable that a trust is duly registered, because ultimately this all endeavor of succession planning is through this legal trust, and it should be stabilized first. Registration is a public notice. It is advisable that must be done. And to the second part, you mentioned that whether trust is a separate legal entity or not. Is that the question? So in strict sense, trust is not a separate legal entity in itself. It acts through the trustees. But for some purpose, some logistical or facilitative purposes, as Manoj sir pointed out, that trust can hold share, it can have its own PAN, it pays its own taxes, although under representative assessment. But for those limited purposes, it can be considered as having a quasi or a nuanced legal entity.
Okay. Manoj, in case of irrevocable trust, how capital gain will be computed?
There is a specific judgment based on which it is decided that because it is a special rate of duty applicable under Section 112 of the Income Tax Act, the special rate of 20%, or as may be applicable in case of listed companies, 10% subject to STT may be applicable. But otherwise it is based on the beneficial owners who should, based on which rate of duty need to be decided. So for capital gain, obviously, for all Indian beneficiaries, the rate of duty would be 20% for long-term capital gain and 30% or maximum rate for short-term capital gain, except in case of listed companies. So that is the rate capital gain.
Another question for you is, can a sole beneficiary of a trust force the transfer of the assets in his own name?
Beneficiaries have no right to enforce anything unless specifically mentioned in the trust deed. So trust is totally governed by the trust deed. And if the settlor has provided that in case of certain, let's say, in case only one beneficiary is left, then the trustee would transfer those assets to the beneficiary, then only it will be transferred. Otherwise, beneficiary cannot ask for distribution from the trust, as per my opinion. Ravi may add something if he wants.
No, you're absolutely right, sir, because once it is transferred to the trust and it is not a determinate trust, then it acts like an HUF where the interest or the beneficiary share is indeterminate. So one cannot sue because one does not know. One does not say how much I own in the trust. And beneficiaries do not have such rights in the trust, except for enjoying the benefit. They can't really seek a partition from the trust.
Sir, I think Ravi, even in case of determinate trust, and if there is only one beneficiary, still if the trustee does not allow distribution, he cannot seek the distribution of asset or transfer of asset in his name.
Yes, unless until the deed provides.
Let's say father is transferring the asset to the trust, only assuming that this person will waste that money in that asset, and he want to protect that asset, and hence he has transferred this asset to a trust. Then it is useless to transfer to the family trust if the beneficiary can ask for distribution and then sell it or something, do it anything what he wants.
Yes.
So that protection would not be available.
You're right. There is no inherent right with the beneficiary to seek partition or to, extract assets out of the trust.
Right.
Manoj, how tax implication under 56 to 10 will be calculated in case the exemptions are not available?
So as I think Dr. Rajkumar Agarwal sir has already discussed in detail, in case the beneficiaries are persons who are exempted under section 56 to 10, then there will be no tax at the time of transfer of asset to the trustee. Otherwise, in all cases, it will be taxed as a gift tax, which is income from other source. So it will be taxed in the hands of the beneficiary or the trustee as a representative assessee of the trustee, and it at the maximum marginal rate of the person.
Ravi, can the trustee who is also a beneficiary participate in decisions that concerns her as well? Is there the principles of conflict of interest applies in case of these trusts?
So because principles of conflict of interest, they also find their place in common law, in the principles of equity. So the general opinion, the usual opinion, or we say the accepted opinion, is that the trustees, while discharging their functions as trustees, even though they are the beneficiaries, they must discharge that fiduciary duty, and they should not get caught in any situation which would lead in conflict of interest. And since you have pointed out, this should also be taken as a key consideration while drafting the trust deed, that conflict of interest clause should be put, and it should be delineated what kind of possible conflict of interest can happen and how to avoid them. What are the situations in which the delegation or authority matrix should tell that this person, if he has conflict of interest, some other person would take on the shoes and he would be precluded, on the lines of 188 and other concurrent provisions of company law, maybe some other laws as well.
Ruchika, there is a question, I'm not clear what it means. It says Regulation 10, are beneficiaries of the trust not beneficial shareholders?
Regulation 10.
It says Regulation 10.
Basically, I think the person wants to understand if the beneficiaries are the part of the promoter group, then and as per the income tax, they are the assessee, basically. Then why not they should be considered to be the beneficial owner or ultimate owner, and then exemption may be granted automatically. And that is, I think, the belief. But as Ruchika has already explained, trust is not at all mentioned in the list of persons who can seek automatic exemption under takeover regulations, and hence it is treated as a separate ownership structure, because it may be discretionary, it may be determinate or non-determinate. So without looking into all those facts, specific exemption need to be taken from SEBI.
Will there be similar stamp duty implications in the first instance when the property is transferred to the trust, and at the later instance when the property is transferred to the beneficiaries? Will there be dual stamp duty implication?
Yes, in case of distribution of asset by the trust as per the trust deed to the beneficiary, stamp duty implication can happen.
Ravi, whether the Trust Act in any way outlines any qualifications for trustees?
Yes, it does outline disqualification. A person who is charged of or convicted for moral turpitude cannot be appointed as trustee. A minor, of course, cannot be. And discharge insolvent cannot be. So the general principles based on which laws exclude someone from holding a fiduciary position, assuming that the person would not be fit for discharging that fiduciary position, those principles also apply for trustees.
And whether the settler can himself become one of the beneficiaries or the trustees in a trust?
Well, there comes consequences if settler becomes a beneficiary on the taxation part, but there is no restriction. He can become beneficiary. Manoj sir said categorically that out of 3 roles, one can choose 2. Not all 3, but 2 can be chosen.
Okay. Manoj, when the ownership and control of property vests in the trust or a trustee, have you come across instances where the trustees have misutilized their position? And in such case, what are the remedies available to the settler or the beneficiaries?
So as Ravi has said, this is a contract and it is a contractual obligation, and it is governed by the trust deed. So the person who is acting as trustee is under fiduciary duty and is governed by the trust deed. So yes, there can be instances of fraud by the trustee because it is a breach of trust, right? So and breach of trust can happen anytime. For that, remedies, civil and as well as criminal remedies are available against that person. So, but in general sense also there can be a situation like in case of professional trustee, a fee is determined, and if there is no appreciation in the value of the asset, the fee can be taken out continuously and the asset value can reduce. So in that case, the asset property can go, trust property can go, and so the general obligation, as Ravi was also pointing out, is to act as a prudent person should do for his own asset. That is the test. If he is not doing that, that is a breach of trust.
And whether the trustees be paid remuneration?
Yes, it can be, and they can be. And in case of professional trustee, it is generally determined in the trust deed itself.
Ravi, can the trust deed provide that in some future time, the property will be ultimately transferred to the beneficiary?
It can be. It can be. I mean, this is linked to the question which Manoj sir answered in the previous
Will there
batch.
be any implication once the properties are transferred to the beneficiaries?
Yes, there would be stamp duty and tax implications. Those would have to be seen based on the nature of property and to the extent they entail. But once the property is taken out of the trust, I mean, the bigger question is whether it may result in permanent dissolution of trust, or I mean, some of the properties can be thrown out and still trust can continue.
Yeah. Yes, tax implication can happen because let's say section 56(2)(10) is there, which talks about transfer and deemed income in the hands of the persons who is getting. So, but if they are relatives and the tax is already exempt under section 56(2), then they are getting exemption, then there cannot be any tax implication in the hands of the person
at the time of distribution.
Yes. But if they are not relative, if they are totally unrelated persons, then there can be tax implications.
But if you're talking about distribution of benefits amongst the beneficiaries, there is no double taxation,
Yeah,
because
there
assessment
is a pass-through,
represented.
there is no double taxation.
Yeah. So there is a pass-through, which is now very well established through
Yes.
various finance acts. So there is no double taxation at the level of beneficiaries.
Can one assign specific assets to specific beneficiaries in a determinate trust?
Yes, that is the whole purpose.
That is the purpose of the determinate trust.
Okay. So Whether shares can be allotted to a trust which is not registered?
As already told, the trust is not a separate legal entity. It is the trustee. So trustee, and it is well settled position that the trust can be created without even writing. So it can be oral trust also, and the trustee can own the shares on behalf of that trust.
In fact, the very fact that trusts are not mandatorily registrable under the Registration Act, only when there is an immovable property. So if a trust which is only holding securities, registration might not be required as a.
Yes.
But in case of listed companies, when you go to SEBI to apply for exemption, they are asking for a registered trust deed only. So at
Obviously.
that point of time.
Yes.
Yeah.
So the basic principle, no notice of trust express or implied can be entered into books of the company unless it is specifically disclosed. So if you are registering and then providing that deed, then only they will recognize you as a trustee. Otherwise, they will assume you to be the absolute owner of the property.
Right.
So thank you, all of you. We are done with the questions. If any question is left, as always, you are free to write to us to seek specific explanation. We will be replying to your queries as and when you share us the relevant query. So moving ahead, next week on 15th July, we are having the next webinar on the topic of UPSI, and it's a contours and criticality of deemed UPSI under PIT and its disposals under LODR. Vivek, if you can put the thumbnail on the screen. Vivek, are you there? Okay, so we'll share the relevant details to you through the usual mediums by which you get our updates. Thanks for joining us for this webinar and such good numbers. Thanks, Manoj, Ravi, Ruchika, and our other panelists who joined us for a short time in today's webinar. Thank you all.